Good day, Crime Talk aficionados. It is Saturday, December 11th, 2021. What does that mean? Well, it's Saturday, and that means that it is time for the weekly Crime Talk recap of all the top stories throughout the week. Thanks for watching. We'll see you next time on Crime Talk. Let's get to the docket, okay? There's been some new filings in the Lori Vallow, Daybell matter. As you may recall, Mark Means has made some pretty significant allegations, basically stating that the people that are trying to restore Lori Vallow to competency somehow are trying to influence her into obtaining new counsel, and apparently provided the information to call the attorney for the Church of Jesus Christ of Latter-day Saints, aka the Mormons. Well, Mark Means filed a motion a couple of weeks ago, and he wanted subpoenas, you name it. It was completely, I think, outrageous. It's called Do Your Own Investigation. What authority, if any, does Mark Means or the courts in Idaho have in Utah? Well, little to none. Well, the Mormons, the Jesus Christ of Latter-day Saints, they filed their responses. It's basically a motion to quash or modify the subpoena. And basically they're saying, hey, the information that Mr. Means is requesting is either A, privileged, or B, not relevant. And some of the information that they have, the Mormons are basically saying, we're going to allow the court to review it in camera, which simply means the court will review it and see if there is some relevance to the case and whether it should be produced or not. Now, what the judge will do in this particular case, I am not sure, but I hope that somebody puts the hammer down for sure. Mark Means also filed a response to the motion, which basically is that Mark Means should be held in contempt for basically doing lots of things that they consider to be unethical, that the prosecutors consider to be unethical, by making allegations, not backing it up, not conducting any investigation whatsoever, and basically just laying out untruths in his motions. And the prosecution also basically said, hey, Mr. Means isn't really qualified to handle this case, hence the reason why the court appointed on its own motion a death-qualified attorney, a guy by the name of Mr. Archibald. And as you've noticed, Mr. Archibald doesn't join in any of the pleadings filed by Mr. Means. Well, I think we now know why. All right, so in the defense motion and objection for contempt, basically Mark Means says that the prosecutor, Mr. Wood, is a witness and that he is unethical, and cites once again to the conversations that Mr. Wood has had with witnesses in this particular case. Now, it's old news. It's a transcript that took place with other witnesses of basically family members of Lori Vallow. I think what is rather interesting is that in paragraph 5 of the motion, Mr. Means states, furthermore, this is an attempt to continue to drive a wedge between co-counsels in the defense of Lori. This court, sua sponte, appointed Mr. Archibald as a death penalty counsel in a case in which no death penalty notice has been filed in this matter. The court appointed Mr. Archibald as co-counsel, and it is self-evident, and there are competing theories of defenses and avenues of advocacy or Lori as illustrated in this matter. This conflict is a direct assault on Lori's right to counsel of her choice and unnecessary interference to her rights to a unified defense imposed solely by the court. Wow. Basically what that means is that Mr. Means is saying the court is sabotaging his relationship with his client by appointing a qualified criminal defense attorney on the case. Pretty bold allegation indeed. I'm not sure you want to say that unless you can actually back it up. The court did in fact appoint a death-qualified attorney, Mr. Archibald, which means he's done the requisite number of felony trials and knows how to engage in defense mitigation, whereas Mr. Means has never tried a felony case. The court did that because everybody and their brother knows they're going to go death. And they, being the prosecution, is going to go death as it relates to Lori Vallow. They've done it for Daybell. They're going to do it for her as well. And either way, even if the prosecution didn't go death, she still needs a qualified criminal defense attorney, not some guy that was basically doing divorce law and somehow this case winds up on his desk. He's out of money. He gets court appointed. The court appoints somebody qualified, and he's complaining. And he basically says there are different theories of defenses, and the defense isn't unified in how they think this case should be handled. Well, Mark Means, I would think I'd probably defer to the more experienced criminal defense attorney in this regard, because in all honesty, you've screwed up just about everything that you've touched in this case, and it's just a little weird how attached you are to your client in this particular case. How can you be sure that she wants you as an attorney because she's not competent? And it maybe took you over a year to decide to question that competency. I think you should sit back and probably defer to Mr. Archibald on this. And yes, start carrying his briefcase. All right, let's talk about this case up in Michigan, okay? This is the case where obviously some bad things happened at the school, and we're trying not to go into it, and I'd love to get into specifics, but the reality of it is those censors at YouTube will shut us down. So if you haven't heard, the mother and father of the teen accused of going into the school and ultimately killing 4 classmates appeared Saturday morning during arraignment on involuntary manslaughter charges. Jennifer and James Crumbley pled not guilty to the charges. Now, the couple's 15-year-old son is facing 4 counts of first-degree murder, terrorism, 7 counts of assault with intent to commit murder in connection with the incident at the Oxford High School last Tuesday there in Michigan. He is scheduled to return to court on December 13th. Now, the prosecutors say that the parents had recently purchased the gun their son allegedly used in the shooting, and that they did not take steps to address concerning behavior hours before the shooting. Now, it's alleged that a teacher spotted Ethan researching ammunition while in class on Monday, the day before the shooting. It's alleged that that teacher then telephoned and emailed his mother, who didn't reply but did text her son, "Laugh out loud, I'm not mad at you. You have to learn not to get caught." Well, the teen parents were immediately summoned to school the following morning when a teacher saw a note the boy had written that alarmed her to the point she took a picture of it on her cell phone. The note included an illustration of somebody with a firearm and a bullet with the words, "The thoughts won't stop, help me," and blood everywhere. This is all according to the teacher. Now, the Crumleys were told to get their son into counseling, but they refused to take him home and insisted that he should return to class. Shortly afterwards, he began the massacre. Now, deputies made arrangements with the Crumleys' attorney for them to turn themselves in at 2 p.m. on Friday with an arraignment set at 4 p.m. They didn't show, but the attorneys representing the couple say that they were not on the run. The couple was arrested early Saturday morning in the basement of a commercial building in Detroit, near where their vehicle was located. The sheriff says that we believe that they were assisted in that location. Now, the Detroit artist whose studio harbored the couple while they were hiding from the police said through his lawyer that he has a friendly relationship with the couple, but was unaware that they'd been charged with involuntary manslaughter when they came to him for safety. The artist is not being charged with the crime at this time. Jennifer and James Crumbley are scheduled to return to court on December 13th. Now, this is where it gets interesting. Under Michigan law, involuntary manslaughter is punishable by not more than 15 years in prison. That's quite a chunk of time. A fine of $7,500 or both at the discretion of the court. Now, Crumbley's parents, it's alleged, unintentionally caused the death of 4 victims of the shooting. So to make sure we get it completely accurate, what do? That's right. We go directly to the law. So here is the Michigan model criminal jury instruction, which the judge would turn to, as well as the prosecutor and the defense, decide what has to be proven. And it would state the defendant is charged with the crime of involuntary manslaughter. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. Remember, ladies and gentlemen, beyond a reasonable doubt is not a vague, imaginary, speculative doubt, but a doubt that would cause people to pause in matters of great importance. So the second element, first, that the defendant caused the death, and then you put the name of the deceased in there. That is, the name of the deceased died as a result of the act by the defendant. And then they would put in using gross negligence. Okay? What is the definition of gross negligence? Gross negligence under the Michigan statutes and the jury instruction 16.18 Gross negligence means more than carelessness. It means a willful disregard, the result to others that might follow from an act or failure to act. In order to find that the defendant was grossly negligent, you must find each of the following things beyond a reasonable doubt. First, that the defendant knew of the danger to another. That is, that he or she knew there was a situation that required him or her to take ordinary care to avoid injuring another. Second, that the defendant could have avoided injuring another by using ordinary care. Third, that the defendant failed to use ordinary care to prevent injuring another when, to a reasonable person, it must have been apparent that the result was likely to be serious injury. Okay, that's a big definition, ladies and gentlemen, but what does that really mean? You basically have to know that something was going to happen and you failed to act. Gross negligence, a grave deviation from a standard of care, okay? But what is the issue here, ladies and gentlemen? If there was such a grave fear that something was going to take place, then the police should have been called immediately by the school. It wasn't. I'm speculating that the conversation in the counselor's office was, hey, we got this concerning picture. The words, the drawing scares everybody. Oh, I was just drawing it, had a bad day, whatever. You know what I'm saying? They dismissed it. The schools didn't call the police, so why should the parents have done that as well? I get it. These type of cases are very emotional. People want other people to be held accountable for, let's face it, it's a massacre, right? A completely unnecessary massacre. But you have to look at the law, okay? Is young Ethan going to prison for the rest of his life? I think the odds are very highly likely. Of course, we'll give him the presumption of innocence. Who knows what his defense may be, but the reality of it is, if he's convicted, he's never getting out of prison. And I just don't get why people do these types of massacres, okay? Seriously. It is probably one of the most cowardice things that you can do, right? You go into an area where no one else is armed and you basically start plucking people off, so to speak, okay? How cowardly can you be? If you had any guts whatsoever, why don't you go to the police station and try that? Why? Because they knew that it wouldn't last very long. And guess what? The police would shoot back. People don't go and start shooting at gun shops. Why? Because all the gun people are armed. These cowards don't want anyone to shoot back. It's that simple, ladies and gentlemen. And that's what they are absolute cowards. However, we'll see what evidence comes out. I'm a little skeptical. It doesn't take much to, charge somebody in a case, but I'm not sure this charge is going to stick. I don't know. I think the prosecutors may be forced to charge somebody at the school, because if this was such an imminent and obvious danger, why didn't the school react? You can't just blame the parents. And buying somebody a gun that apparently is locked up and that the kid took without permission of the parents, unless there's some information that the parents knew or encouraged him to take that firearm, I just do not see how that charge is going to hold up. We'll wait and see. My opinion may change based upon new evidence, but color me skeptical. All right, Scott Peterson. That's right. He's the man who was convicted of killing his pregnant wife, Laci Peterson, and their unborn baby. Well, he was resentenced today to life in prison without the possibility of parole for his wife's death back in 2002. For those of you who are not familiar with this case, it was kind of a big deal. But Laci Peterson was 27 at the time, and she was 8 months pregnant with their son, Connor, when she was killed in December of 2002, 5 years after she had married Scott Peterson. Now, prosecutors alleged that he had dumped his wife's body in the Berkeley Marina on Christmas Eve and then tried to cover up the crime by making it appear as Laci Peterson had disappeared. Wow, I guess it just isn't a recent phenomenon, is it? No, it's not. A judge sentenced Scott Peterson to 15 years to life in prison for the death of the unborn baby, Connor, and the sentence will run concurrent with the judge's sentence of life without parole. Peterson is now 52 years old and has spent more than 15 years on death row since his murder conviction. Last year, his sentence was overturned by the state Supreme Court there in California after it was determined that a juror who disagreed with the death penalty were in fact dismissed from the trial. Now, Peterson has tried to have his conviction overturned, with his attorneys claiming that a juror, known as juror number 7, was untruthful, and she didn't disclose that she was in fact a victim of domestic violence. Now, before he was sentenced Wednesday, Laci Peterson's mother, sister, and brother all addressed the court. Sharon Roca said she still feels grief 19 years after her daughter's murder, and that she has never seen any sorrow or remorse from Scott Peterson at all. Laci's sister, Amy Roca, said, even though the death penalty has been lifted, you will still be punished in this life and after. Now, if Peterson is granted a new trial, his attorneys say that they will present new evidence that supports their claim that Laci Peterson was killed when she stumbled upon a burglary at her house. A hearing on those allegations is scheduled for late February of 2022. We'll see what happens there. Who will Josh Duggar, rhymes with hugger, be hugging tonight in custody? I don't know. His name could be Butch or something. I don't know. Jurors in the Josh Duggar's trial returned early Thursday morning with their verdict after deliberating for 6 hours. Mr. Duggar was found guilty of all charges regarding possession inappropriate images of minors. Now, Mr. Duggar apparently then broke down in tears as the United States Marshals handcuffed him, and he mouthed, "I love you," to his wife, Anna, who was inside the courtroom and has been there by his side the whole time. Now, Mr. Duggar's father, Jim Bob, put his hands in his pocket, looked down, and hugged Anna. The trial lasted 8 days in federal court there in Fayetteville, Arkansas, and the prosecution showed over the course of the trial, and the jury had to consider during its deliberations, images that were from Mr. Duggar's computer device and described to the jury and the steps that took to scour the dark web for these videos. Now, Mr. Duggar's defense attorneys fired back, saying that Mr. Duggar did not have the technical skills of a computer hacker capable of finding such images, and also unsuccessfully used the defense that someone else could have accessed his devices. Now, Mr. Duggar's sister, Jill, who is also one of the victims from his previous transgressions, made her first appearance at the trial on Wednesday, and she had been named as a potential witness. Now, the Judge Brooks, declared Duggar will remain in custody due to the seriousness of his crime, and the sentencing date will be set out in about 4 months. So let's talk about this. First, I told you early on, these are difficult cases for the defense. The only defense is that the defendant was not the one behind the keyboard. Well, that didn't quite work in this particular situation. The defense called in an expert. The jury rejected that testimony that it was possibly somebody else that could have used this computer. But the fact, more than likely, it was Josh Duggar's own statements, particularly where he asked about, or you hear about the images, before the agents even started questioning him. Not good. And then the other defense, which was basically, my client's too stupid to figure out those fancy computer things. Unless, of course, he really wanted to have those images, which the jury said those are his. So what's going to happen now? Well, the judge revoked Mr. Duggar's bond, which is not unusual given a case like this. He will remain in custody. He's not going to get probation, ladies and gentlemen. Mr. Duggar is going to prison. The court will order that a pre-sentence investigation be conducted. It will be background information about Mr. Duggar's youth, his education, his family life, any issues that may have caused him trouble throughout the years, to see what sort of rehabilitation may be possible. They will also do what they refer to as a psychosexual evaluation. And they'll basically ask Mr. Duggar to talk about very embarrassing things and why he may have a proclivity to prepubescent children. Those reports are sometimes a little embarrassing to read. Now, if Mr. Duggar does not comply or do the participation in the psychosexual evaluation, it will bode even more negatively for him at sentencing. Then the probation officer, they call them probation officers, but you don't usually get probation in federal court, prepares a report, and they will do an analysis under the criminal sentencing guidelines. And under the federal sentencing guidelines, they will look at his criminal history as well as the offense here. And they will do the calculations, and they will look at this big table and say, this is the presumptive sentence that Mr. Duggar should receive. At that point, the defense will then file a motion under 18 United States Code 3553A, which is a motion for variance, basically saying that, Judge, although those federal sentencing guidelines that used to be mandatory but are now simply advisory, that you should consider a much lower reduced sentence, arguing that the court needs to consider the appropriate sentence and not sentence Mr. Duggar to a sentence no greater than reasonably necessary to accomplish the rules of sentencing, which are basically punishment, deterrence, not only to Mr. Duggar, but those that are feeling familiar with his crime, as well as rehabilitation of Mr. Duggar in the future so when he does get out of prison, he doesn't do this again. All right? Now, there's going to be restrictions more than likely in place when Mr. Duggar is in fact released that he may not be able to be around anyone under the age of 18, including his own children. That varies from jurisdiction to jurisdiction and judge per judge. So you just have to wait and see. This was a case where early on I figured that it was going to go to jury trial, even though the evidence appeared to be rather overwhelming. And apparently there was little doubt in the jurors' minds at all that Josh Duggar possessed these inappropriate images. But I have seen it very often when somebody who comes from a very religious family and there's something of a sexual nature, they would rather go to prison for the rest of their lives than to admit they did something wrong and inappropriate. And I think that's kind of the case of Mr. Duggar. I had a case years ago. Evidence was absolutely overwhelming. Only thing that was ever told was it never happened. Okay, we went to a 4-week trial. The jury deliberated 32 minutes because it was so obvious as to what was taking place. It was obvious to everyone except the defendant and his family. So that's what happens. We wish Mr. Duggar well. Hopefully no one wants to cuddle with him, but he is going to be on the bottom of the food chain in any prison system when you're convicted as basically being a chili mo. Okay? That's it. You're a child molester. You have images. You're a child molester. Bottom line. Good luck, Mr. Duggar. We'll follow this as the sentencing proceeds. All right, that's all we have for you today. Thanks for watching. We'll see you next time on Crime Talk.